And we don't want to confirm that this workshop is beginning a little bit late because it's being organized by Brazilians. So we are starting our workshop on Internet governance principles. It's called Initiatives Towards Improvement of a Global Internet Governance. The main goal of this session is to present some initiatives that had been going around in recent years relating to Internet governance, and especially in the framing of principles, recommendations, codes of conduct, best practice, declarations pertaining to rights, principles that could be used to frame a general discussion on a number of issues that are important for our discussion related to Internet governance. And for this sense, we are going to have some small presentations from people who have been involved in one or more than one of those documents, and see if we can not only understand a little bit the process behind the creation of those documents, to know a little bit more of the content of those documents, and then after the presentations, the idea is for us to open up for questions from the audience and among the panelists, so that we can analyze, compare, and see the relations that we can create here and analyze and examine between the documents. So the general idea of this forum is to understand, or to not to come up, of course, with like final answers to some questions as why are we seeing this great number of charters on Internet governance in the last years? So the idea is to put the question like, is there an urge for conceptualization and the setting of principles in the global Internet governance? What are the circumstances that created this scenario? So what are the scenario behind the creation of those instruments? And most importantly, what specific questions those charters want to address? It's important to highlight here that different charters answers different questions. So important here for us to understand what are the demands, what are the circumstances that led a certain group to work on principles, to work on charters on Internet governance principles, and then try to understand a little bit on the process, what were the best experiences on the process that created those documents, and the content of the documents themselves. So I would ask the panelists just to introduce themselves briefly. And I will ask Carlos Afonso to start introducing himself. Look, please, that the two Carlos Afonsos are sitting together in order to make it a little bit more confusing on the organization of the panel. So, Carlos, go ahead.
Mm-hmm. Yeah, if you look closely, you notice that one is older than the other. I am Carlos Afonso, and I participated of a diverse group of people in 1994, 1995, which helped create the Brazilian Internet Steering Committee. That was in May of 1995, and which was basically in charge of governance of the .br domain name and IP numbers in Brazil. Some of you may know that Brazil is one of the few countries in which IP numbers are distributed through a national coordination and not individually directly to the operators or providers. So let's start. Okay. Pardon, sorry.
So this was me telling Carlos that was supposed for him just to introduce himself. So and now it seems that like mission accomplished. So I would ask the other panelists to introduce themselves as well.
My name is Dixie Houghton, and I work for Global Partners and Associates in the United Kingdom, and I'm also the interim chair of the Internet Rights and Principles Dynamic Coalition.
I'm Joy Liddycote, project coordinator for a project on internet rights and human rights with the Association for Progressive Communications, and also the chair of the regulator of the Domain Name Commission Limited in the .nz space.
Romulo Neves, the head of the Division for the Information Society, Minister of External Relations.
I'm Wolfgang Kleinwächter from the University of Aarhus, and I chaired the Cross-Border Internet Expert Group in the Council of Europe.
So thanks everyone. I'm Carlos Afonso from Center for Technology and Society in Getúlio Vargas Foundation in Rio de Janeiro. So beginning our presentations, I would ask Dixie to make the first short presentation. The general idea is that every panelist gives a short presentation on the specific document, or no longer than 10 minutes. So it's going to be really short and like even shorter than 10 minutes. And then we open up for discussions. Okay, so Dixie, go ahead.
Okay, so I'm going to talk about the Charter for Human Rights and Principles for the Internet, which was developed by the Dynamic Coalition of Internet Rights and Principles. The coalition is a multi-stakeholder group of individuals and organizations who are dedicated to upholding human rights in the internet environment. We were formed in 2009 when two different coalitions merged. One of them was looking at creating a Bill of Rights for the internet, and the other one was looking at defining policy principles for the internet. So those kind of represent the two elements to our approach with the Charter. We are both trying to apply existing human rights standards to the internet environment, and we are also trying to elaborate on those policy principles which are necessary in order to uphold the human rights maximizing potential of the internet. The process was going around, being spoken about for a long time, but it really got started in 2009 with a collaborating exercise. So a wiki was set up, and anyone who was interested in this initiative could go onto that wiki and put exactly what they thought was important into it. And so what came out of that was really broad-based involvement. A really broad group of actors from many different countries and many different stakeholders fed into that. And what came out in the document was, of course, a really, really wide range of issues. But as collaborating exercises often are, it wasn't necessarily the most easy to use document. So the next stage was to identify 6 human rights experts to go through that document and to channel it down and to make it usable and make sure that it was all coherent and that it was all in line with human rights standards. So there were 6 experts, and the most prolific of them was Miriam Marzuki from European Digital Rights and Wolfgang Benedikt from the University of Graz. That resulted in a version 1.0 of the Charter, which we launched at the last IGF. And that workshop was a really, really dynamic space. The room was packed full of people from, again, across different stakeholder groups and from different countries of the world. And we got a lot of really rich, really, really useful feedback. So immediately after the last IGF, we went back and we went through all that feedback that we'd received and tried to incorporate that which was useful and that which was relevant into making the document much stronger. And at the same time, we identified some of the more controversial issues, and we had quite intensive discussions within the coalition about those issues to decide what the best way and the most human rights respecting way of dealing with them would be. So what came out of that was our beta version, which is our current version. But as you can probably tell by the name beta, it's not viewed as a final set-in-stone document. This is an emerging process. And just to highlight now, I think 2 of the things that we really learned from that process as being very valuable ways of working is, 1, to be very open and to allow people to engage, because people will come up with thoughts and perspectives that you wouldn't come up with if you had a small group. I was just talking to someone earlier from India who said she only got involved because she thought that we weren't giving enough attention to access to information, which is clearly vital element. And if we'd had a small group, we could have missed out on some major things. And the second factor, I think, that is important to learn from this process is that human rights were the underlying factor, and they were the sieve, if you like, through which we could make sure that what went into this document was going to produce a people-centered internet environment. And just to say that 2 separate documents have come out of this in the last year. One was a feeling that the Charter as it is a fairly long piece of document and not that easy for newcomers to engage with. So we distilled it down to 10 key rights and principles, and I've got lots of copies of those here, so if you're interested, please do grab a copy. And we also had an international law expert look through the Charter and produce a legal commentary, which was going through each of the articles in the Charter and saying to what extent they are already established parts of international law, to what extent they are emerging, and to what extent they are still progressive. So a bit about the Charter now. So the aim of the Charter is to define what stakeholders need to do to produce a people-centered information society. We were building on and taking inspiration from the APC Internet Charter, which you'll hear more about in a bit, as well as the Universal Declaration of Human Rights, the Geneva Declaration of Principles, and many other pertinent documents. As a human rights document, it is aimed primarily at states. However, in the Universal Declaration of Human Rights, it says that every individual and every organ of society has a duty to promote and respect human rights. And so we also envision this being guiding for the private sector. And that's clearly an emerging area of law, as we saw recently with Ruggie's protect, respect, and remedy framework, that a growing understanding is that private sector as well have some responsibilities under human rights standards. The Charter is made up of 21 articles covering the full range of human rights, not just civil and political rights. It was very important to us to also look at economic, social, and cultural rights, and also to include internet policy principles. I'm not going to go through them all right now because I think that would be a bit of a waste of time, but if you want to look at it, you can find it on the Internet Rights and Principles Coalition website. Instead, I've just chosen a few articles which maybe are interesting for the discussion today. The first I wanted to talk about is access. I'd say this was one of the most controversial debates that we had within the coalition and from people outside the coalition. On one side, people said access to the internet is not a human right, that it will undermine the Charter, that human rights have both positive and negative obligations on states, and we should only be focusing on the negative ones, telling states to hands off rather than to take positive action. And then there were all the questions as well about what would that right actually mean? Who would have a responsibility? What type of access are we talking about? On the other side, and the winning side, I should say, was first the argument that without access, we would be undermining the whole Charter. We don't want to say that once you have access to the internet, you have access to a whole load of rights, but until that point, you have no rights. That seemed to make no sense to us, so that was one element. The second one was the idea that access is fundamental to so many human rights, not just freedom of expression, but also education, assembly, association, work, and many more, that in order to really fulfill any of those rights, access was necessary. So to that extent, it is a de facto right. And then the final argument was that it is perhaps an emerging right. Last year we saw the BBC survey, which found, I can't remember the exact percentage, but a very high percentage, I think the high 80s, of people questioned across around 30 countries, both developed and developing, thought that access should be a right. And in these circumstances, we thought a progressive and forward-looking document should definitely include it. I also want to say at this point that Frank, who is over there in his report, didn't say that access was a right in itself, but also made the argument that it is a fundamental aspect of many other rights. And the way that we've approached access is that it both includes the negative, the hands-off requirement of governments to not shut down the internet, not produce internet kill switches, not take people off the internet for violating intellectual property, but it also includes the positive element of promoting digital inclusion, particularly for marginalized groups. And within the access section, we're also dealing a bit with quality of service, which we say should evolve along with technological possibilities, which is perhaps a bit of a cop-out, but I think it's fair enough, seeing as it would be very hard to be more specific and probably counterproductive. It also talks about people having the freedom of choice of system and software use, which is also viewed as an important aspect of access. And it also includes network neutrality, which we think is an important aspect of access. I'm just going to talk about a few other points. Another one, which I think is particularly pertinent at the moment, is around the right to culture. And we've taken the approach from the Universal Declaration of Human Rights that the need is really to balance the rights of the creator with the public interest. And so in that section, we include things like the need to promote cultural and linguistic diversity, the need to use and promote permissive licensing models, fair use limitations, and the promotion of free and open source software and open standards. Another issue that we didn't know whether to include or not was the right to a legal remedy and a fair trial. Some people felt that we shouldn't include it because it doesn't have a particular internet dimension. But on the other hand, this is a human right that seems to be forgotten an awful lot in our approaches to controlling the different types of content and activities online which various actors want to control, particularly in terms of filtering and blocking and intermediary liability. And so in that circumstance, we thought it's very important to promote the fact that this human right is still relevant today and is still relevant in an internet age. And the final issue that I want to bring up is the right to an appropriate social and international order for the internet. Under Article 28 of the Universal Declaration of Human Rights, people are entitled to an appropriate international order in which their human rights can be realized. And that needs to be applied to internet governance as well. We need an order which will allow us to realize human rights. And that means both like effective participation in internet governance, which includes things like multilingualism, and that also means respecting principles such as openness, inclusiveness, and accountability, and exercising those in a transparent and multilateral manner. I'm going to conclude now just to say that we are in quite a different space now than we were when we started making this charter, as evident by this actual panel. And so I think within the IRP, we have a bit of a decision that we need to make now. We can either focus still on talking within ourselves and trying to build our own perfect charter of what we think should be the way, or we need to start looking outwards more and engaging with the processes which are going on often by actors who have much more economic and political power than us, and trying to have an impact there. Thank you.
Thank you, Jixi. I'll ask Carlos Afonso to go ahead and talk a little bit on the 10 principles of the CGIBR.
Okay. Could you, who turns the slides? Okay. No. Yes. Oops. Yeah. Okay. This effort by CGI.br is a product of a so-called multi-stakeholder organization, which I would like to take about 2 or 3 minutes to explain. The CGI-BR was created in 1995, as I was beginning to say earlier, and it was constituted as a multi-stakeholder group, but the members of this group were selected by the government. In 2003, the members, the non-governmental members, began to be selected by their own constituencies in an electoral process. And this is, I think, a significant difference between 1995 and 2003. Next, please. Distribution is currently the distribution of the Internet Steering Committee is 8 representatives of the federal government. Today we have, I think, 2 ministers of state as representatives, and other representatives of other areas of government, federal government, 1 representative of science and technology secretariats of the states, and 4 representatives of non-profit organizations, non-profit, non-commercial organizations, 4 representatives of business, 3 representatives of the academic sector, and 1 senior expert chosen by consensus as part of this. So 21 members, and there is an executive secretariat which takes care of the operational matters pertaining to this board. So it's a commission, it's not a formal institution, it cannot open bank accounts, it cannot manage projects, etc., etc. Okay? Next, please. NIC-BR is a formal institution which is linked to the commission called CGI.BR. Several of its board members are members of CGI-BR as well, but not necessarily so, because there is a period difference, a time lag between the periods in which you are a member of the Administrative Council of NIC-BR and in which you are elected to the board of CGI.BR. And it has a number of functions, which is the registry and registrar of the .BR CCTLD. It also is in charge of coordinating the distribution of IP numbers, which is not there. It operates several internet exchange points in the main cities, which are neutral, non-profit exchange points. It's run by a division of NIC-BR called Septro.br. It maintains the Brazilian CERT, linked to the network of CCERT's service. It's home of CETIC.br, which is an internet and ICT research center which has produced every year statistical data on users and the penetration of the internet in Brazil with several visions. No? It supports the Brazilian chapter of W3C. It works with the National Observatory in maintaining the National Atomic Clock and associated NTP service, supports national and international events and projects related to ICTs for development and internet governance, and provides technical assistance in managing CCTLDs for countries in Latin America and Africa. This is part of the activities of NIC-BR, which is the formal institution, which can run bank accounts and operate projects and so on. Next. So the principles, which is what we are interested in. Can you go to the next one, please? Okay. That was in 2009 and took more than a year to produce. Given the multi-stakeholder nature of the process, there were several interests which I can't say that they were in conflict, but where they were emphasizing different aspects of each of the principles which we are going to present. It started as a list of about 15 or 14 principles. It shortened to 8 or 7, and then it was enlarged again, and ended up by coincidence as a list of 10 principles, which is not to coincide with 10 commandments or anything like that. Okay. Why we did that? We did that because we needed a set of concepts which basically would orient our work. We have a significant presence on the Brazilian internet in the matters that you have already seen deriving from the projects that we operate. No? And this was a guidance for us to orient new projects, orient our intervention or our participation in several fora, etc. But we wanted it also to be considered as a reference, not necessarily the reference, of course, with its values and shortcomings in other fora, national and international. So this was the main focus of the idea. So they are 10 principles, and the first is basically freedom, privacy, and human rights. And basically, the use of the internet must be driven by the principles of freedom of expression, individual privacy, and the respect for human rights, recognizing them as essential to the preservation of a fair and democratic society. Well, not much to say here. I don't think anybody would disagree with that, I hope. No? Second, please. Democratic and collaborative governance. Internet governance must be exercised in a transparent, multilateral, and democratic manner with the participation of the various sectors of society, thereby preserving and encouraging its character as a collective creation. This basically is mapped from one of the Tunis agenda principles, no, which was generated in Tunisia, in the WC's process. Third is the universality principle. Internet access must be universal so that it becomes a tool for human and social development, thereby contributing to the formation of an inclusive and non-discriminatory society for the benefit of all. And the fourth, diversity, I think this is one of the important principles, particularly given our cultural diversity in Brazil. And I understand that this can be applied everywhere. Cultural diversity must be respected and preserved, and its expression must be stimulated without the imposition of beliefs, customs, or values. 5, innovation. Internet governance must promote the continuous development and widespread dissemination of new technology and models for access and use. No big deal here. I think it's pretty agreeable. 6, I think this is important and took a bit of time for us. Unfortunately, Joy, I cannot give a picture of the process with which we arrived at this, no? Like you described in your presentation of the rights in the dynamic coalition. Would take a long time to do that. So network neutrality for us ended up as being filtering our traffic privileges must meet ethical and technical criteria only, excluding any political, commercial, religious, and cultural factors or any other form of discrimination or preferential treatment. This is linked to the 7th, so which I present now. The 7th, please. Network unaccountability. Every action taken against illicit activity on the network must be aimed at those directly responsible for such activities and not at the means of access and transport, always upholding the fundamental principles of freedom, privacy, and the respect for human rights. 8, functionality, security, and stability. Network stability, security, and overall functionality must be actively preserved through the adoption of technical measures that are consistent with international standards and encourage the adoption of best practices. And 9, standardization and interoperability. This is, of course, basic. The internet must be based on open standards that facilitate interoperability and enable all to participate in its development. And 10, legal and regulatory environments. Legal and regulatory environments must preserve the dynamics of the internet as a space for collaboration. This set of principles was one of the bases used for the formulation of the so-called framework, I don't know what the proper translation is, civil framework? Yeah. Civil framework of rights, which is in public consultation in Brazil, and this, we hope, will become a law defining clearly what those civil rights are and regarding these new technologies, in particular the internet, which our junior here will be presenting later on. Okay? Thank you.
Thank you, Carlos Afonso. And going from one international experience to one national experience, I would like to ask Wolfgang now to speak a little bit on the Council of Europe draft declaration on Internet governance principles.
Yeah, thank you very much. The Declaration on Principles of the Council of Europe goes back to a decision by the Ministerial Conference of the Council of Europe in May 2005 in Reykjavik, when the 47 member states of the Council of Europe just, decided to look into the feasibility of a legal instrument for cross-border internet. The question was, people had the impression, the member states had the impression that something should be done to manage this, in particular with regard to the cross-border function of the internet. And normally an intergovernmental organization works on the basis of treaties, that means of legal instruments, hard law. But also the Council of Europe has a lot of recommendations and declarations. So when then the expert group was established based on the ministerial recommendation to study the feasibility of such a legal instrument, the first thing we discussed in the group was, okay, what should we propose? A treaty, like the Council of Europe hosts the Human Rights Convention, the Cybercrime Convention, and other treaties, or should we look into other options? And should it be just an intergovernmental instrument, or should we look also into, based on the definition of internet governance, into should we include also other stakeholders in the whole process? I think when we started the debate, it was already the composition of the expert group was multi-stakeholder. So I think it was a very wise decision that the Council of Europe said, okay, when we move into this still unknown territory, we cannot do it alone as government. So that means we have to open up. And the group was a small group, only 5 people, but representing the various parts of the society. And all the meetings was in an open environment, because we invited other experts, other groups, and there was a permanent consultation process backwards and forwards, with the Bureau and the CDMC. This is the sub-ministerial committee which deals with this. So that means that was a process which went over 2 years. But coming back to the two key questions we had in the beginning: legal instrument, yes or no, and intergovernmental instrument, yes or no. With regard to the legal instrument, we were a little bit inspired by the human rights legal framework, because the Council of Europe is based on the Human Rights Convention. It's the only intergovernmental organization which has really a court behind the convention. The Human Rights Court is linked to the Council of Europe in Strasbourg. And if you go back to the history, then you could say, okay, about human rights, there was a discussion in the 19th, 20th centuries for decades, and only after World War II, after the shock, then governments realized something has to be done in this field. And when Madame Roosevelt chaired the committee, they had the same question. Should we go to legally binding instruments first, or should we start with, let's say, a soft law approach in form of a declaration? And I think that was a very wise decision, because so immediately 3 years after the end of World War II, in 1948, the Human Rights Declaration could be adopted, and it needed another 20 years to negotiate the two conventions on political, civil rights, social, economic rights. So that means our question was, if we really propose a legal instrument, probably this will need 20 years until we have a result on the table. So our approach was then it's much more better to take this approach, what was taken after World War II, and to look into general principles. And there's a great difference between principles and rights. So that means I enjoy very much your concept on internet rights and principles, but you have to make also a distinction, what a principle is and what a right is. Anyhow, we decided then to move forward with a declaration of principles, or let's say a number of principles. And here it was very helpful to have both your work and the Brazilian 10 principles, because this was the first thing really which was accessible at this time, and it was very balanced. And what Carlos just introduced, was exactly what he had hoped for. It was an inspiration for other groups, and well drafted, and we took this. And then when we discussed further, we said, okay, while the Council of Europe is an intergovernmental organization, but the internet, has to be managed in a multi-stakeholder way. And so the question was, how we approach this conflict between, let's say, multilateral treaties and a multi-stakeholder environment. And our conclusion also in the very early days of the work of the group was that we will continue to have a multilateral treaty system, but the multilateral treaties in the future probably will be embedded in a multi-stakeholder environment. That means the multi-stakeholder governance principle, is more or less the more general principle. And from this approach, then you can go to the specific rights, duties, and responsibilities of governments. Governments are an important stakeholder, though. That means they will not disappear in the next 200 years. So, and that means the intergovernmental system will remain as an important element in the international scenery. But it's, has a specific role. It's not the only band in town, you could say. So there are also other players, and the challenge is, how to link this together. And insofar, it was an interesting experiment, how to move forward. And I think a very good starter for this was that the Council of Europe is really the human rights organization with its 47 member states. And there was an agreement, if human rights is the starting point for all policies and principles in internet, then it's much more easier to handle the other questions. And so the first principle in our declaration is human rights, rule of law, democracy, very similar to the Brazilian declaration. And then in the second principle, we say, okay, this can be achieved only if all stakeholders are working together. So the multi-stakeholder governance principle is our second priority. And then we come to the role of states and all the other principles, which has been partly also similar language in the Brazilian document, like open internet, like end-to-end principle for the architecture, like empowerment of users, and all this. I think that's why I went to these two procedural issues, the relationship between hard law and soft law. The soft law approach enabled us really then to come rather quickly to a solution. And as you have heard, the Ministerial Committee have adopted this declaration just a couple of days before the IGF here. And more or less, this was adopted in a way that you could say this has entered into something new territory, because in the preamble you have a paragraph which says that the governments hope that this can be now further enhanced to other stakeholders. And what we propose now to the Council of Europe, to see this as a phase 1, because it was adopted by the governments, and to move now to a phase 2, where we start a process of multi-stakeholder collaboration, and to get the commitments not only of governments to the principles, but also of other stakeholders, private sector, civil society, and other organizations, so that Google, Facebook, the IETF, ICANN could also subscribe and commit themselves to this type of principles. We have called this a framework of commitment. So that means the declaration of principles, which was adopted by government, is not the end of the story. But looking forward, that means we have to have indeed the commitment also of the other stakeholders. Otherwise, these principles remain empty principles. We had a workshop on Monday already. We call this is a constitutional moment in the history of Internet. And indeed, if you compared it with the Human Rights Declaration, this was also a constitutional moment, because based on the Human Rights Declaration, then you can develop a body of law, a body of very other instruments. And insofar to have first such a clarification about a framework, I think will be very helpful for future efforts to organize, govern, regulate, or whatever, small pieces of the Internet, because there will be no general legislation for the Internet. You have to go it piece by piece, and then you have always to identify whether a regulation is needed or whether just a policy is needed. Sometimes regulation is not needed because we have enough regulation already for many things. And if you look deeper into an issue, then you say, okay, what is the difference whether you steal money online or offline, and you have enough law, which can fight against these crimes. Sorry for being too long.
Not at all, Wolfgang. Thank you very much. And I would like to go now back again to a national experience and ask Romulo Neves to do his presentation. And now I realize I'm being quoted Carlos Jr. Okay, thank you for that, Daddy. So, Romulo, go ahead.
Thank you, Junior. Okay. Sorry.
You're a member of family as well? You know those big Portuguese families in Brazil? Go ahead.
Okay. Well, my task here is talk about our civil framework of Internet. That is not kind of principles that should be adopted internationally, but a kind of framework within the discussions about the very important subjects related to the Internet could be discussed in Brazil within a legal framework, comprehensive framework. The demand for such a framework appeared within the civil society. It has come from the civil society, and then the discussion took place in the Brazilian Internet Steering Committee, and then it was adopted by, especially by the faculty School of Law of the Foundation, Getúlio Vargas Foundation, and then it was adopted by the Minister of Justice. Well, just a bracket. There is some ways in Brazil that the people can propose directly a law in Brazil, but it's needed nowadays 1 million signatures to try to send some proposal to the Congress. Just to have an idea, with 3,000 votes, you have a representative in the Congress. But to propose a law in Brazil directly, you need at least 1 million signatures, because it's 1% of the total of the electors in Brazil. There are a lot of proposals trying to put that number down, let's say 400,000, but nowadays it's like that. So to propose a law directly from the civil society, it would be needed 1 million people supporting it formally. So the decision was the law or the proposal should be presented in a website by the Minister of Justice. It was a very good coincidence that the Minister of Justice has, at that moment, a very young team, and they accepted the challenge to start a huge open consultant through the internet. The idea was, since the framework is about the internet, the consultation would be also online. So you can find the website. Afterwards I will give you the link, but it's in Portuguese, but just to take a look. And then people start to comment, to give ideas, to suggest. It was a two-phase open consultants. Itamaraty, the Ministry of External Relations, was demanded to search for experience like that around the world. So we made an international consultation through our embassies to gather information about such kind of proposal or initiatives around the world. This material, this information was sent to the Minister of Justice, and then in August of 2010, the consultation was finished, and then started the work of harmonization. I don't know if that word exists in English, but in Portuguese it exists, and it's the work to put it into a framework, into law proposition. And it's very hard because it was 2 phases of 4 months, I think. The total period was 1 year, so they have a lot of material to organize and to harmonize. And in the end of 2010, we have a government change in Brazil. Politically, it was a continuation, but even in such a continuation, you have changes in a lot of ministries. We have coalition, so the Ministry A went to the party B and blah, blah, blah. And we have a certain delay because in Brazil, when the executive power has a proposal, it needs to send the Congress by the presidency. So we had a delay, but the proposition was sent to the Congress last August, and it's already being analyzed by the representatives. Well, there is a proposal to attach to this proposition the other laws that are already there related to issues about the internet, like cybercrimes, like information security, like other issues. And it explains a little bit how the idea was born. Which these propositions, some of them are older than the civil framework. We're trying to focus on very specific elements of the internet regulation in Brazil. So there was a threat, let's say a threat in the Brazilian legislation to adopt some laws that was very specific in some very specific points that could maybe be in contradiction with other kind of law, also related to the internet, but dealing with another specific issue. So the idea was to put them together and guarantee that such laws were not in contradiction with one with the other. Well, the thing that I would like to call your attention here is that it was a very creative way to put it forward, the very nature of the internet, to regulate itself. As I have said, if it was just by the civil society, it would be very hard to put it forward, because you need a lot of support, and even in a huge country as Brazil, to have 1 million people supporting such kind of law, it would take too much time. It would be necessary a lot of organization and some money. It would be a little bit hard. But then the Minister of Justice, governmental, of course, body, took the responsibility to try to organize the discussion and put it forward in an official way. It was a very good example of interchange, of collaboration, and maybe in some months, well, Brazilian Congress not so fast, but we hope in some months we have a Brazilian internet framework already passed and approved by the Congress. Probably Carlos Afonso will talk a little bit more about the subject within the law, but the process is some kind like that. Thank you.
Thank you, Romulo. I will not go into a formal presentation. I would like just to go through some of the articles of the Marco Civil. Marco Civil is a Portuguese name that we could be translated into civil rights framework for the internet in Brazil. So we have like in this part here of the screen. I'm not sure if you'll be able to read it properly, but if you could go a little bit down, so just to, it's okay, thank you. So just to explain a little bit, we have this test as a result of this online consultation that Romulo has mentioned. We have received more than 2,000 comments from people from civil society, government, law firms, enterprises and companies, academia, technical community. So it's very interesting to see the diversity in the quality of the stakeholders that were presented in this consultation that resulted in this test. It was really hard to come up with a test like that after receiving 2,000 comments. So this for us was quite new, so we are still in the process of studying and analyzing what we have been doing and to try to come up with best practice on the process itself. But certainly it was very hard for us to come up with a wording to compile and to be something that related to the majority of the comments that we received. One of our great challenges was how to address people who have contributed in the Marco Civil process, for them to say, my comment was well received and adopted in that specific provision, and why my comment and why my argumentation wasn't that much taken into account. So what was the reason behind that? So this is the process that is still an ongoing learning process for ourselves to understand how to better address those questions. But certainly we have, as a result, this test, and in Article 2, we have something that connects directly to Carlos Afonso was mentioning about the 10 principles of internet governance from the CGIBR. So a number of principles that have been mentioned by Carlos Afonso are contemplated in those very first articles of the Marco Civil. So you have in Article 2, openness, collaboration, plurality, diversity, and human rights, and the exercise of citizenship in the digital environment as the basis for the regulation of internet in Brazil. It's, of course, it's a more broad article, it's more broad disposition, but it was important to have that in order to connect directly to the work that the CGIBR has been doing and to create this connection to the work that has been conducted in the previous years. Article 3 of the Marco Civil is also interesting because it deals with privacy and protection of personal data, and this is a very sensitive issue because Brazil does not have a framework on privacy, a specific general law on privacy. So Marco Civil had to be very aware of its borders in order not to conflict with other legislative process that are going on nowadays in Brazil, and the creation of a law for privacy and data protection is one of those cases. So we have privacy and personal data as principles for the regulation of Brazilian internet, as well as the seventh item is interesting because it says the preservation of the participatory nature of the internet as one of the principles of every single regulation of internet in Brazil. If we go a little bit down further on Article 4, could you please? Article 4 deals with the objectives of the regulation of internet in Brazil, and this article interesting because it talks about the promotion of innovation, and Article 4, Item 4, is very interesting because it promotes the compliance with the open technological standards to allow communication, accessibility, interoperability between applications and databases. So it is a commitment to the further regulation that is applied to internet in Brazil is committed to open standards. So it's good to have that as one of the objectives for the new regulation of Brazilian internet. Then going a little bit further down, let's go to Article 8, or even better, 9. Article 8 through 9 talks about the preservation of rights to privacy, and so 8 says that preservation of the right to privacy and freedom of expression in communications is a condition for the full exercise of the right of internet access. And this is important because the right to access internet is contemplated as one of the principles, and in a number of occasions in the Marco Civil, you have the affirmation of the right of access as a fundamental right. It can be a statement like this one, or it can be in situations in which you prohibit states and private parties to degrade or to shut down the access to internet through non-legal reasons, and it connects us to the net neutrality provision on Article 9 that says that the party responsible for the transmission, switching, or routing of data has the obligation of granting equal treatment to every data package with no distinction by content, origin, and destination, service, terminal, or application. Any traffic discrimination or degradation that does not arise out of the technical requirements necessary to adequate provisions of service is prohibited in accordance to further regulation. So Marco Civil is intended to be the first step towards further regulation of the Brazilian internet. So our idea is to set the principles. So our idea is not to go that much into details, but to set the standards and to set the borders in which further regulation will be encompassed. And then if we can go to Article 15, please. Article 15 was the most controversial one, and then I finish my comment on the Marco Civil. In the consultation, the first version of this article that now is Article 15 that related to liability of intermediaries. The first version of this article, it contemplated position, an article that is a little bit similar to the notice and take down with some difference from the experience that the US has on the notice and take down for the removal of content online. We received huge criticism at the Marco Civil platform, at the website, from the users, from the community of the Marco Civil, as well as from the press, as well as from a number of players that said, like, this is censorship, because content will be removed from the internet without a judicial order. So listen to the criticism that we received in the consultation. We changed the wording of the Bill of Law, of the draft Bill of Law, and now we have this Article 15, that's the wording that has been sent to the Congress, that says that except otherwise established by law, internet application providers, this will be like ISPs, can only be responsible for the damage caused by content generated by third parties if, after receiving a specific judicial order, they do not take action to, in context of their services and under established time frame, make unavailable the infringing content. So we remove the notification parameter to a judicial order as a way to assert civil responsibility in the internet, torts, for torts damage. So those are a number of topics of the Marco Civil. There are a bunch of other articles that has created some controversy. We have, unfortunately, a data retention provision of 1 year that has been subject of a long debate in our consultation, and some good provisions on open government that had been contemplated in some way in a new legislation that has been issued last month by the President of Brazil on open government standards for Brazil, for the Brazilian government. So this is just a general idea of the Marco Civil in addition to what Romulo has said. So now switching from Marco Civil to the last experience that we had to showcase and to bring to light to discuss, I would like to ask Joy to join the presentation on APC's work on Internet governance principles.
Thank you, Carlos.
Can I ask a clarifying question at this point?
Sure, go ahead.
Can you tell me what the difference is between the 10 principles that Carlos described earlier and the 15 articles that are in the Marcos review? Are they the same? Are they different? Is one legal and the other not? Can you
Sure.
just clarify that, please?
Okay, sure. And just for to help the transcriptions, when you see Marco review, we are talking about Marco Civil, which is the difference of criminal, civil and criminal. So sorry about that, but there's a Portuguese accent that sometimes can be hard to track. So the difference is, and Carlos Afonso, please correct me if I'm mistaken here. The 10 principles of the CGIBR were adopted by the Brazilian Internet Steering Committee. So it was the result of a long discussion as principles that should guide the regulation of the Internet, but the Brazilian Internet Steering Committee is not a regulatory body for the Brazilian Internet. It deals with the registration of domain names through the NIC-BR, as Carlos Afonso has mentioned, and it has consultation qualities, abilities. They are often requested and has the government represented in its body to create some expert advice to the way Internet is addressed in Brazil in technical and legal issues as well. And the Marco Civil, the civil rights framework, is a different process that is now a bill of law that is being discussed in the National Congress. So we have first this discussion on the Brazilian Internet Steering Committee, and having this discussion and having a huge debate on a cybercrime bill in Brazil that generated this civil rights framework initiative, we end up having this initiative that was a partnership between the Ministry of Justice in 2009 and our law school in Getúlio Vargas Foundation to create this online platform in which people could contribute to create this bill of law that has been sent to the Congress last month.
So if I could just then ask, are these in harmony with each other or in any way in conflict with each other?
No, in harmony. So this was one of the aspects that were commented a lot in the Marco Civil platform. A number of people that has
Carlos,
been contributing.
can I just ask that, just in the interest of time, if we could move to the last one?
Sure, Joy, and I'm really sorry about that. We tend to get excited when we talk about the Marco Civil and the CGIBR. So,
can you continue?
And sorry about that. Is it clear? It's okay. And sorry, Joy, to take this
That's
amount of your time. Go ahead.
We're going to have a gala dinner tonight, and I'm sure you'll have an interesting discussion over it.
You don't want me discussing this in the
I'm
gala
feeling the weight of responsibility at 5:40 on the end of the second day in a hot room where everybody is busy doing their emails and trying to stimulate you. So I have no PowerPoint, so I will just try and make my points powerful instead. No disrespect to my fellow participants, of course. I've said previously at the that essentially, I mean, APC is an Internet Rights Charter. You all have charters and principles. At the end of the day, these are just pieces of paper. They only have the meaning and power and moral authority that we give them by how we behave and how we act. And I've said previously in this forum that, in my view, human rights are as fundamental to internet governance as internet protocols are to the DNS. And to illustrate my point, I'm going to actually talk about the internet protocol. I'm going to talk about the DNS and some of the core values which underline that system, which I think are usefully brought to bear in a discussion about the internet governance and rights. And my first point really is to recall, and I do this from my experience as a CCTLD regulator, is to recall that in the early days, internet pioneers recognised that internet functions were themselves required trust. And that in effect the internet was a public commons that relied on the good conduct of those who used it to operate it to its maximum potential. And while the issues and the demographics and technical matters that we comment on today are very different, I think it's mindful to recall how it was that the internet itself was created. And that was through a very democratic process. It was through a process that the technical community pioneered. And I appreciate there are pioneers and gurus in the room present today. And those who've gone before. And I recall, for example, the very process of a request for comments on a version of protocols. And the one I would particularly comment on is RFC 1591, which in a sense proffers that those who are operating CCDLD domains are doing so in the public good, and that they should be able to carry out their responsibilities in an equitable, just, honest and competent, as a competent job. And that the manager is spoken of as a trustee to the global internet community. And that, and I quote, concerns about rights and ownership of domains are inappropriate. It is appropriate to be concerned about responsibilities and service to the community. What's this got to do with human rights? Well, I think it's fundamentally a call to the moral authority of the public commons and how we behave, how we regulate, how we engage in that. And the other thing, of course, was that RFCs were adopted not by vote. They were adopted through a very democratic process of rough consensus, where the contest was a battle of ideas and practical things that would work. And so too, if we turn to human rights, the Universal Declaration of Human Rights is not a binding document. It only has the moral legal force that nations of the earth gave it when they signed on and said, these are our basic human rights that we as governments, all governments who are members of the United Nations, have ascribed to. So I think when we are talking about this contest of ideas and this notion of rights, the question, I guess, is what are we building in terms of a movement around internet rights and principles and governance? The technical community, I think, has led the way. I think human rights community has led the way, and I think internet governance provides an opportunity to bring the best of these together to create something more than a simple restatement or a reapplication of existing law to this new forum. Although those things are essential and critical, and indeed that's why APC developed its Internet Rights Charter, because we were struggling to frame human rights in the context of this new paradigm. The other point to note in the human rights framework is that governments are not rights holders. We, as human beings, are rights holders. Governments are duty bearers. They are obliged to respect, protect and uphold our rights. And one of the tensions we are seeing, and I think one of the reasons why, to answer the question that was posed to us, why are we reaching for rights frameworks in the discourse of internet governance, is because we are increasingly seeing that what is done in the name of our rights by duty bearers is increasingly raising questions about the realisation of our rights, whether it's filtering, whether it's internet content blocking, and many, many other questions, some of which you've touched on. And some would say that perhaps the question is even becoming problematic. I'm not sure I would go that far. So my concern, I suppose, when it comes to this question of rights, is it's wonderful to see, I suppose, what I've earlier called elsewhere in this forum, the blossoming and the flourishing and the blooming everywhere of rights. The Brazilian initiatives, you know, the demonstration that they're giving others about how to have multi-stakeholder forums, and they're not alone. There are many others, and indeed the IGF itself is a place where new and multiple forms of diverse participation are occurring. And why are we doing this? Because in a sense, rights and rights principles provide not the place for merely assertion of our rights, but also an articulation of our duties and our obligations, and a negotiation through democratic processes of where we find balance and points of sometimes very rough consensus, or sometimes no consensus at all. So I suppose my question, you know, do we need a meta principles document? Do we need a further and better and stronger articulation of rights frameworks in relation to internet governance? To that, I'm not sure. But I would like to see a greater critique and a greater realisation that actually human rights are already infused in the fabric of internet governance arrangements, particularly across and outside government arrangements, and that those are the points I think where we can dialogue and say, do we need another forum? Do we need to create another process? Or shall we watch with curiosity and wonder at the principles and rights that are being articulated, and participate in those discussions and dialogues with a view to looking at this process as an evolutionary one, rather than a final point in time where somehow our rights are magically crystallised forever in the final statement of what our rights are, and also what our obligations are. So with those few words and a call to wake up in the last few minutes of our session, I'll close there and open, on behalf of Carlos, the floor for dialogue.
Thank you, Joy. And it's totally my fault for leaving this little time for discussion, but let's take the best of it. So I would take questions for the floor. So let's go. We have 1, 2, 3, and 4. Okay. So, so Vint, please.
First of all, I really want to applaud the notion that we talk about the environment that we wish we could have in this network. And second, we pay attention not only to the rights and privileges that we want, but the obligations that we have. There are many parties and many actors that make this network function. And if we can characterize some of the obligations and responsibilities that we undertake in order to achieve the environment that we want, I think we will achieve a balance. And I'm not sure that we've talked enough about obligations and responsibilities.
Thank you, Vincent. Just go through all the 4 questions that we had in the first. So, Bill, were you in the queue?
Thanks. Sorry. Bill Drake. All these efforts to formulate principles, I think, are interesting. And one of the points that Carlos made at the outset, I think really hasn't been picked up on very much, is what is it about this historical moment that we seem to have all these initiatives going on? And one, in part that's because the net and the environment around the net has matured to a certain point. Interests have kind of configured themselves around the space, and people start looking around for ways to try to provide some kind of guidance on certain things. The problem, I guess, I have sometimes with this is that the process isn't always driven by a need to resolve particular types of problems. It's like the old notion of whether institutional form should follow function or not, right? I mean, if you've got a particular functional problem that you're trying to redress, you go about trying to work through, what types of principles, norms, rules, decision-making procedures, instruments, institutional frameworks you have to devise to resolve that problem. A lot of these have sort of been, I've felt like, not addressing particular defined, bounded problems, but rather people sitting down and trying to say, let's map the space and say, what are the things that we think are good that should shape the space? So rather than working sort of inductively, from the bottom up to resolve particular problems, we're kind of like doing these top-down exercises of thinking about, how to visualize something. And we end up with these lists of principles, and G8's got one, OECD's got one, everybody's got one, but they're kind of floating in the air by themselves. There isn't an elaborated set of stuff below it, and many of them can be interpreted in zillions of ways. You could spend weeks, months, years to come up with a principle like everything should be good on the internet, or something like this. I mean, you look at some of the stuff that the Chinese and the Russians have put into their list code of conduct. And they're kind of empty until they're really specified in relation to particular problems. And I wish that there was a way that we could engage more at that level rather than just at the level of creating top-level global principles, because they, to me, often end up feeling like they're either stating the obvious, or they're kind of empty, or they're not going to be implemented, or they're going to be implemented in a million different ways. And I don't know how useful an exercise that becomes, ultimately.
Thanks, Bill.
Sure. This is Bill Smith. I wanted to echo Vince's comments. The discussions here the presentations were, I thought were excellent. But for me, I was somewhat surprised by them. I came here thinking that we were going to be talking about the principles as principles for internet governance. So for me, those principles would be things like transparency, openness, inclusivity. I absolutely agree with the rights as I've seen them expressed here and elsewhere, and the principles that may be behind those. But I was expecting a different conversation, and I think only the Council of Europe, actually, their 10 principles addressed any of these things with respect to what internet governance, the principles upon which internet governance itself should be based. So I ask if any of the panelists want to respond to that.
Thank you. Eduardo?
Thank you. Eduardo Bertoni from the Center for Studies on Freedom of Expression and Access to Information. It's a quick question or a quick comment and question. I agree with the idea that normally it's much better to start with soft law and then pass to hard law. This is what happened not only in the human rights environment. It is true. In the Inter-American system, for example, we passed first the Declaration of the Rights and Duty of the Man before the UN Human Rights Declaration, and the Inter-American Convention on Human Rights was enacted 30 years after. The same happened in the anti-corruption movement. We started with declaration from the civil society, soft law declaration by the countries, resolution by the General Assembly, and now we have a convention of anti-corruption at the UN level, and those are normal process. But the internet is something different. My question is, if the idea to start with soft law, having in mind to have hard law at some point, the timing is something that concerns a little bit of me. I think that we are going to have soft law plus soft law plus soft law, because we never will have hard law, because the timing of the government to pass treaties that are binding are not, in accordance with the timing of the evolution of technology, particularly the internet technology. So I'm not saying that we need a treaty right now, because that will not happen. But my question is, what we have in mind when civil societies like global partners are working in this charter, or the Council of Europe is working on a declaration of what is the final goal of all of this? Is a treaty? If that is the case, I have some concerns because of the timing.
Thank you. We have time for like 2 more questions, and then we open up for the panelists. Go again. So, go ahead. So, I have 3 questions. So go. Yep, please.
Thank you. Sebastian Rwengabo, Singapore Internet Research Center. I wouldn't want us to think that the human rights concerns that have to do with the internet or internet governance are a special content of, or is component of human rights. Human rights are human rights. What I think is that we can think of or work towards integrating human rights concerns having to do with the internet with the rest of the international human rights regime, and then we look at the uniqueness of the internet-related human rights, see what kinds of instruments we need to put in place to bring human rights, internet human rights-related international cooperation, so that it doesn't appear as if we are invading states to say, constitute a new human rights regime based on the internet, because states always tend to be resilient against forces of human rights protection. But I think the steps being made so far are important, and it's important now that we collaborate through either regional IGF human rights organizations, start engaging regional IGF fora across the world, so that each of them begin to debate, to engage, and to discuss human rights issues, so that quickly and more effectively we can bring it to the agenda of the international community. Thank you.
Thank you. By the end of this table, we have to be very quick on our comments. Okay, so go ahead.
Okay, well, I recall how surprised and pleased I was when the Brazilian principles were introduced at the Vilnius meeting last year. And I think discussions like this have a certain helpful, bring a certain helpful perspective to the issues of what individual countries and organizations should and will do in the future. However, I tend to look at these discussions and ask, how can they be brought down to ground? How can they be made practical? What can we get out of them that is tangible? And I think ultimately it comes down to sort of how we view the internet itself. To me, and I don't know that everybody would share this view, but to me the internet is a method of interconnecting a lot of individual components and capabilities and resources, whether they be networks, computers, applications. I mean, it's the protocols that really make the internet what it is, and in some sense, they are the technical governing factor. We can talk about the social institutions that help to evolve them and that sort of spread the word, but ultimately, the only thing that you can expect is that the operators and owners and proprietors of these different capabilities will adopt rules and principles subject to the laws in which they operate, and that's ultimately where the rubber hits the road. So when we talk about rights, there may be rights that one derives in a country by virtue of what a government does. If we're talking about principles, they could apply to a given operator or a given applications provider of some sort. But I don't think we'll ever get to the point where there are specific legal constructs that apply to the internet as a whole, protocol-wise or other, because it's just too broad a concept. It's got to be applied in a local area by a local authority that's got responsibility for either administering something or governing something.
Okay.
Thank you.
Thank you. I'm afraid we have like two more very quick comments on, unfortunately, on the back. So please go ahead.
Thank you. Andrew Cushman from Microsoft. Thank you for an interesting presentation on the Brazilian internet experience. Very helpful and informative. I was almost expecting a further discussion about the recommendations, seeing how that built with CGR, BR, and then to the Marco Civil. I was almost expecting a discussion about the recommendations that came from the IBSA meeting, the multi-stakeholder meeting. So I'm wondering if you have comments about that, and then a follow-on to the question earlier, are these in harmony or aligned?
Okay, thank you. So that will bring us to the gala dinner, certainly. Okay, so our last comment, Frank, go ahead.
Thank you, Alfonso. First of all, I would like to congratulate the panel. I was very eager to see the different approaches. One of the issues that we have to be very clear is that one of the reasons why we're doing this, and I think everyone is doing this, because it's going to happen anyway. I mean, this initiative of China and Russia as a code of conduct to be discussed in the General Assembly is moving, and it's moving fast. And I think it's very important that the EU has its own set of principles and others, because I think it's good to balance off some of these initiatives. Secondly, I think what we have said already, and we have mentioned it with the new charter, the idea that in terms of human rights, I believe that we're not dealing in establishing new human rights, but we are dealing in establishing principles or guidelines that would decide what will be the governability of Internet. And I think this may be crucial, and I love to hear the example of Brazil, where actually one of the articles was modified precisely because at the end it was discussed that within a human rights framework would be censorship, and therefore it was added that only the takedown notice would only happen if it is done by a judge. So I think this is a very good example of applying human rights standards and interpretation. So one of the probably the ideas we should jointly push, if this is a consensus, is precisely that even if principles are being drafted around the world and in different regions, at least we should draw the consensus that should be inspired from a human rights perspective.
Thank you, Frank. We are certainly over our time, so I would just pass to our panelists to make one quick final comment. I would say that is almost a principle not to go through a lot of details on the apes discussion in our discussion on principles here, but I'll please ask the panelists to speak briefly just for us to make a closing here. Joy, if you want to start as your last
I think that's fair. I think that's fair. I have a very concrete suggestion, and that is that I think the governments which are proposing resolutions in relation to internet governance, this is my personal view, not the view of APC, I think they should bring them to the Internet Governance Forum. I think that is the place to discuss those resolutions. And it is not amongst governments in a forum that is not multi-stakeholder. And I think that would be a very good concrete recommendation or suggestion or outcome from this proposal. Is we would love to discuss those proposals. We would love to have multiple perspectives on them, and we would love to have them here, where we can discuss them openly. Thank you.
Thank you, Joy. And just to before giving the floor for very quick comments, final comments from our panelists, just would like to remind you that we have on Friday a workshop in conference room 2 on global internet-related public policies. Is there an institutional gap, which could be a good continuity to the discussions that we have begun here, but that's just to make almost like in a movie to be continued. I'm so sorry that we really ran out of time here, but I would like to give the floor to the other panelists if they would like to make some final comments. So please, let's go through backwards in the order. So that will be yours, Romulo.
Oh, it's me?
Yep.
Okay. No, very brief. Bill, you asked me for some provocation in the beginning. I'm afraid sometimes we are a little bit nihilistic, because this is going forward, as Frank Leroux told us. This is going forward. We need to participate in it. We need to put our voice on it. We cannot say it's useless, first thing. And the second thing is, I totally agree with Joy that this is the constitution, the place for this debate, and it's why we bring our document to be discussed here. And very finish. The milestone of such discussions are important. We don't know the end of the process, but the milestone that points that where some decisions, some doubts, some problems were solved, and new problems will appear. And totally agree with Eduardo. This is a very serious problem of our issue here, but the milestone should be evaluated, I think. Then we create new problems, and then solve new problems, and then so on.
Thank you. Wolfgang, if you want to jump in.
I can only agree what Vint said, that there are no freedoms without responsibilities and no rights without duties. And insofar, we should have to look, or we have to look into both directions. And by the way, the Council of Europe adopted another document which more specifically tries to define as a first step specific rights, duties, and responsibilities for states. Because you have to be very specific if you come to the concept of rights and duties and responsibilities, you know, just to avoid to be elsewhere in the sky and then to have something, you know, which is nice to everybody but doesn't help. And this brings me to the second point, the binding law question. So I think Bob made it clear. It's totally unrealistic to regulate the internet as a whole. But you can identify some arenas, very small slices where you probably agree after a long discussion process. A binding law would be helpful. But then first, clarify the issue, define the issue, what you want to regulate, and not just say, you know, we need regulation. So what you want to achieve with the regulation. I think this is important. And the final thing, you know, I call it now the principle tsunami, that we have, you know, endless waves of new principles. And the risk here is that we end with principle shopping. So that just, you know, parties say, okay, they justify their bad or good behavior by referring to a principle which is elsewhere adopted and say it's laid down there. So that means you have to come to, I would not say synchronization or harmonization or something like that, but insofar, you know, what Joy said, that's the only way out, you know. We have to bring all this to a table, you know, the non-governmental declarations and the governmental declarations and the principles. And, you know, we have 4 years to go with this Internet Governance Forum now. So, and this will take some time. But this would be really a very good outcome for the IGF if they come in 2013 or 14, you know, with something which it goes beyond the governmental principles or the private sector principles or the civil society principles, and would, you know, have commitments for all stakeholders, which then will help to keep the internet open, free, and secure.
Thank you, Wolfgang. Carlos?
Okay. Very briefly, I thank especially Joy Liddicoat for the excellent remarks. And I would just add that this civil framework is not coming out of the blue. It's also a countervailing, trying to be a countervailing response to many bills of law which we have in Congress, which could make even a bald man have their hair raised. You know? Is really a scary thing. And some of these are proposed out of absolute ignorance of our parliamentarians, but others are proposed out of very deep economic, political interests. And we have to have some framework in order to set the stage, and the political stage, and the legal stage, to countervail these proposals. So this is very important to take into account.
So, Jixi?
Thank you for letting me be on this great panel. And just to highlight again that human rights apply as much online as they do offline, and that I welcome some of the proposals that went on about making a truly multi-stakeholder approach, and maybe the starting basis for that would be if next year the main theme for the IGF would be human rights. Thank you.
Well, thank you everyone, and once again, I'm really sorry we didn't have that much time to go further on the discussion, but I'm quite sure that we can take the opportunity of having everyone here join together for this event, and to take this opportunity to engage in conversation after the closing of this session. Thanks for the participants that engaged remotely, and the persons responsible for the technical organization of our session, and thanks for the audience and for the panelists who took the time to spend here with us and to engage in the discussion. Okay, so thank you very much. See you tomorrow.